Ms. Peetsless, we are going to, you've got 15 minutes for both cases, I understand it, and then defense counsel are going to have 7.5 minutes.
That's my understanding as well.
Arguing. Good. Thank you.
No, you're here under 211.3.
But I have findings, and
Yes.
I'm not in the middle of a trial.
No, I'm going to say you're all right, because it meets the test of an important statutory problem. It affects the entire administration of justice and the whole district court system, and you've, at least on one of the cases, got the seal of approval by the single justice who reserved and reported it.
Well, and in the second matter, the full court said that this was my only appellate remedy and that I was deserving of the extraordinary exercise of the superintendent's power.
What I'm saying is you're all right. You're not running into
So
this.
don't panic.
You're not running into this buzzsaw that the last person did.
No.
Before you, I have one question, and I didn't see it in the briefs, but I think it has some impact. Where are the tests given? Are any breathalyzers given on the street?
No.
Oh.
Okay, and the machinery at this point is not capable of performing the test on the street?
Correct.
Or is it?
My understanding is that there is a device known as the portable BT, but that for a multitude of reasons, that is not utilized at trial, nor does it eliminate the need for use of the certified
Not used at trial, you mean
breathalyzer
you mean not used on the street. You said not used at trial.
Well, it's not used at trial. It is the PBT, the portable breathalyzer. There is a device.
I understand, but
that's used on the street. The results of that are not used at trial, and the fact that PBT may have been used on the scene does not eliminate the need for there to be, when an individual consents, to use the breathalyzer device that is at the station, that is certified, that is monitored.
So in all trials, the test results that are introduced are those from the test that's given at the station, is that right?
Correct, the station or a police barracks. Yes.
Is the defendant made, is the person who's arrested made aware of the results of the portable test?
It's almost never used, is it?
Right, it's very infrequently used, and it typically isn't part of a record anywhere because of the fact that it has no viability.
Okay, I just wanted to
anywhere
be
else.
sure that we could assume that these tests are all given at a somewhat later time. Okay.
They all are, and the...
Are you aware of any situation where it has been used, the defendant has been told of the results are more favorable than the results given at, they're taken at the station, and the defendant tries to introduce those results at a trial?
I have, having explored somewhat exhaustively this case state law on OUI, I have not come across any published decisions which indicate that that has happened, nor do I have anecdotally any secondhand knowledge of that personally.
Ms.
Now-
Peetsless,
well,
I'm sorry, go ahead.
Well, I was just going to say, turning to Melanie's law, as so described, the revisions that were made, I didn't, and maybe I misread the provision we're talking about today, which is the breathalyzer. I read it too quickly. I didn't see anything in there that would even hint, imply that there ought to be this retrograde analysis before it could be admitted. Not a word.
Absolutely, Your Honor. I would...
So where is all this coming from?
It's somewhat unclear to me, but I would just want to correct that this is not Melanie's law.
Oh,
this
all
is
right.
Melanie's law is the 2005 amendment.
Yeah, this
is
All
in
right.
fact the 2003 amendment.
Well,
but
okay,
in
well,
neither the
is there anything
2003
in either-
amendment nor Melanie's law is there anything that indicates that because of the creation of the 0.08% per se theory of committing an OUI offense, that there is now a foundational requirement that requires retrograde extrapolation or expert testimony as to what the significance is of the numeric result of the breathalyzer test.
But explain it to me. How is this supposed to work on an OUI, not a per se? You introduce evidence that an hour or 2 hours after the arrest, the person had a .14 breathalyzer, right?
Okay.
What does that mean?
What that means is what has been construed within this state previously is that the jury is free, should they decide that the test is both reliable, was accurately performed, et cetera, that they may make an inference from that.
But how
Where
can
does
they?
it-
How can they without expert testimony? I'm with you on the per se. I understand that, and the legislature, arguably in your opinion, and it may well be, could have adopted the per se. But now they've taken out the inference that used to be there, right?
Well, they've taken it out
They've
because
taken it out
they...
because it wouldn't make sense. If you have a per
That's right.
se, of course they've taken it out. They very sensibly.
Right.
So if it's out and you're not going under, it's not per se. You're not making an argument. You're not proceeding under the per se. How can the jury be instructed that they can draw the inference that .14 is under the influence when there's been no testimony to that effect?
Well, Your Honor, there may be possible to construct a factual circumstance in which an individual under arrest would have blown a .14% BT, and the Commonwealth would only be proceeding on the impaired
Well, that was
theory.
going to be my next question.
But I
Why
can't
don't
imagine.
you always, I mean, do you ever go under, I didn't understand how these cases were, I didn't understand from the briefs, why the other was an issue. Don't you always go per se if you've got an over .08 reading?
Per se and impaired, because
But
certainly...
why do you go impaired?
Well, because it's always a possibility that the jury may make a determination that at the time of operation that they're deciding that either because of the behavioral symptoms or there's something about the test that they're not completely convinced that they can rely on it, that they're choosing to just go on the observations that were made of a defendant's demeanor or whatever.
How can you get an instruction then on the, what do you call it, impaired, if there's no expert testimony, because the jury can't know what a .14 means? Or are you saying that because .08 they're told is per se, they can then deduce from that, but .14 is more, so therefore they don't need the expert testimony? Is that your argument?
Well, my argument only includes part of that. Certainly a jury is going to understand that if a .08 has been determined to be an unlawfully high blood level alcohol, that then if you're considerably higher than .08, that can't suddenly become lawful. It doesn't swing around.
Okay.
But excuse me, the more important thing is that this court has, before institution of the .08%, has in Marley, in Mahoney, in Durning, has said that a jury certainly can, based on common experience, infer from a BT without being told anything.
What's your common experience with the gradations on a breathalyzer? We're talking about people who've read the newspapers and maybe have heard something about .10, .08 means intoxication, maybe not. How can anybody
We said
infer
that in the context of a
From evidence.
statute that
Right.
said that the
Permissible
inference. That statute is gone, so the
No.
jury is no longer instructed that there's a permissible inference.
No, they are instructed that there is a permissible inference.
Of
What they're
impairment.
told.
Of
Pardon me?
impairment. Of impairment.
No,
No.
that's been removed from the
No,
statute.
the permissible inference is still there. The jury would be told, if one is proceeding a trial on both the OUI impaired and the per se, the jury is told that if it's a BT of less than 0.05%,
Right.
there's to be no the inference is you're not under the influence. If it's between 6 and 7%, there's not to be any inference. Then the jury is told if it's 0.08% or higher, it's unlawful.
And from a .08 or higher, it's unlawful.
It's unlawful. So that if, I mean,
Are they
comments
told it's per se operating under the influence of intoxicating liquor?
that it is unlawful, because the .08 is unlawful.
That is
Because
the
this-
element of the crime. Having a blood alcohol level of 0.08% is a crime while you're driving a car.
That's correct.
Of that
That's correct.
crime, but it's not an element of the crime of driving while impaired.
But logic would tell you that if .08 is unlawful to operate a vehicle, and if .05 and below, you're fine, but 6 and 7, you make no inference, .08 is unlawful, then it would really require the jury to be somewhat unreasonable to say, well, if he's got only a .14, then that doesn't go to impairment. Plus the fact you've got to understand that a jury is also, this isn't coming in a vacuum, a jury is going to hear about the officer's observations.
Sometimes.
Well, I believe all the time the jury is
No,
going to be
maybe,
hearing about
yes.
the officer's observations.
Isn't it common experience that jurors would have that one's blood alcohol level goes down as time passes? So that if someone blows a .14 and a couple hour later, they're stopped, it was probably higher when they left the bar room.
Well, I believe that that's exactly what the D.C. Court of Appeal said, and I've cited in my brief. That
Well, I
you
don't know
have
how
to
the
have
jury can
expert
infer
testimony.
that without
Common
expert
sense and
testimony.
common
Well,
experience,
it's
we all
com-
know that.
And I believe it's that court aptly put it, but somebody who was not born yesterday. That because it's
Right.
common sense, whether it be ingesting caffeine, aspirin, or alcohol, at some point it's going to be coming down. All of the courts.
it's
How do you know it's
also
not coming
going
up?
up.
Don't know when.
It comes up and then it
Don't
goes
know
down. How do you
when.
know where you are on that without
Because-
expert testimony?
Okay. Well, I would say This court has never said that in order to admit the breathalyzer test results that we need expert testimony. All of the courts.
They come in. They don't need. I don't think you need expert testimony because it says they come in. But
Well,
then how?
How do you?
Go ahead. I'm sorry. I broke your chain of argument.
Well, but as one looks across every jurisdiction in the country, with the exception of Vermont that does require retrograde, although it doesn't have to be specific in the case law, it's very interesting how that's evolved. What they've said is that a jury is able to make a determination, given what they hear at the time, as to what the officer's observations were, and then put it together with the BT, and throughout all of it, the defendant is always able to call an expert to challenge the fact that in the unique set of circumstances that existed in this instance, that he was in fact in the absorption, so that he was, as one court has put it, in that perilous road race to get home before the BAC got to the unlawful limit. But the thing is, one has to take a look at the cases to see exactly what it is that would require. And in most instances, what it requires is an individual who is literally either doing power drinking and then immediately getting in the car and getting stopped and going for the BT within the hour. And typically, they're drinking right in front of the police officer. It
Ms.
would be a very
Pearson,
unique set of circumstances.
May I ask you this? There are many, many states that have a similar statute, but they require that the breathalyzer be administered within some period of time. The lowest that I found is within 2 hours, and then up as high as 4 hours.
Correct.
When the legislature was making this 2003 amendment, were they looking at what other states had done?
I believe that our presumption always is that the legislature is aware of other legislation, particularly given the fact that we were one of the very last to adopt the .08.
Was there some reason why they didn't put a time limitation? And do you know, I haven't looked at the statutory history, but in other words, in this case, the breathalyzer was, well, in both these two cases, my understanding is that these tests were administered within a couple of hours, correct?
Oh, it's well within a couple of hours. One, the defendant Thomas was 57 minutes and then an hour, exactly an hour, and the defendant Colturi, I believe, was an hour 5 minutes and then an hour 9 minutes for the second one.
All right.
So that it's well under that period of time. The states that either have never had the time limit or have since amended their statutes to eliminate the time limit have been noted by their courts as refusing to have the arbitrary time frame, leaving it for a jury to make a determination whether this was in all of the circumstances reasonable. And that because of the fact that delay typically inures to the defendant's benefit, that it's not to the advantage of the police to delay the breathalyzer, but rather to move as quickly as can be done given the requirements of what must take place before an individual is placed under arrest and brought to have the breathalyzer test conducted.
It seems to me that the defendant's argument is really that the statute is unconstitutional. And couldn't we just say that the legislature knows the tests aren't given on the spot? That's why I was asking you those questions at the beginning. They know that there is a delay. I mean, that's from reading all the cases, there's a delay. And that the blood levels are going down during that time period. And the statute means, assuming that the test is given within a reasonable time and in a reasonable manner, the number at the time of the test is to be relied on. And I would say that would, it would seem to me that would answer the question.
I believe that that's absolutely correct, particularly because our jury isn't told that this is a presumption that unless the defendant takes some affirmative action of introducing evidence to rebut it, that they must find that fact disproven. The jury
What's the
is just
presumption?
simply told
Which presumption are we talking about now?
that the BT result is
Unlawful.
as it stands.
It represents
it's-
his blood alcohol level at the time that he was
Driving.
driving.
Time of operation.
Is that what you're talking
The
about?
jury may make the inference that the BT that is result that is obtained within a reasonable time of the operation is indeed reflective of the fact that the person was at that level at
And
the
may
time.
well be lower, may in fact be more favorable to the defendant.
Indeed.
Most likely is not less favorable because he hasn't been drinking for an hour or
That's-
2 hours, as the case may be.
That's correct. Because unless, typically you would not have an instance where the jury or anybody, fact finder, were told that after the operation and prior to the BT, the defendant continued to ingest alcohol.
Right.
Well, have you
And
looked
so
at the,
there's
have
a
you looked
period
at the
of time.
Connecticut statute? I mean, which is a very well-crafted statute,
Yes.
which basically says you take two tests, right? It has to be done within 2 hours. You take two, one test and then one a half an hour later.
Okay.
And if the test is .12 or below, and the second test is higher than the first test, then you have to bring a retrograde expert in, right?
I did not come across that within my reading of the Connecticut case law, so I can't respond
I'm
to
talking the
that.
statute. I'm not
Right.
talking the statute.
But our legislature didn't pass that.
No, I understand that.
Right.
But the notion that it never goes down or never goes up seems to be very much belied by this statute, which suggests, of course, you need to take two tests because you need to know whether it's going up or down.
Well,
And if, in fact, if the tests are so close, if the first test is so close to the limit and the second test is higher, then of course you need a retrograde expert to come in and testify about what the test might have been if it was given at the time of the driving, right?
well, setting aside the fact that our legislature chose not to implement that kind of statute, the fact is that here with the tests that were taken, the tests are exactly the same.
Yes.
The individual is exactly the same.
That's right.
And the
the
problem-
question is whether we should, whether the legislature, well, the question is whether the legislature has done this in a way that actually is manageable at trial under our ordinary rules about this kind of evidence.
And there really isn't anything that the legislature has done in the 2003 amendments that causes this court's earlier rulings going back more than 2 decades to no longer be valid, because
Which earlier ruling?
Morera,
On what point?
on the fact that the delay of time, as long as it's reasonable, only goes to the weight that a jury may decide to give it. It doesn't go to the admissibility.
You talked about amendments since this 03 statute. Do amendments now make this point moot, or these questions moot?
No.
They're still, these questions
No,
still?
because that part of the statute has remained intact. Any changes that were made by Melanie's law does not affect either the .08 per se or the inferences that can be drawn. But I'd like to point out 2 things, and I think that one of them is, and to that extent I apologize because I believe that I'm going to file an errata sheet. I only became aware of this yesterday. And I believe what happened with the motion judges is that they were confusing the BT result with being an element of the crime. And as Justice Spina said, the element of the crime is the blood alcohol level. The BT result is one of 2 ways to obtain the blood alcohol level, the other one being the blood test. And so when they talk about it being unconstitutional because you're compelling a defendant to disprove an essential element, that's inaccurate, because the BT result is not an essential element, and you're not compelling him. I think what has to be noticed here is if you look at the dockets, these 2 defendants are in substantially the same position. They are individuals who have been charged with an OUI, who have significant BT results, whose motions to suppress have been denied, and they are now saying that we are now compelled to provide testimony challenging the accuracy.
But that's no different than, this law doesn't change that.
That's absolutely
It's always
correct.
been that way.
That's correct.
And we've upheld these tests before.
That's correct. And
That's what she-
certainly,
yeah, that's what she said.
and this court has never said that the fact that a defendant may be faced with very strong evidence of his guilt and attempt to challenge the accuracy of any particular
It's not a burden
evidence would in fact be unconstitutional. And so then I would rest as to the lack of availability for the Commonwealth to actually make a valid retrograde extrapolation. And I would ask the court to enter the orders for us as requested in my brief.
Thank you, Ms. Pietzles. Mr. Monson?
Yes, thank you. Thank you, Your Honors. May it please the courts, Stephen Monson, representing Ann Colturi. I just wanted to correct one thing that my sister mentioned that I don't think is quite accurate. There was not a motion to suppress. These were motions in limine. And what we're dealing with here before this 2003 amendment, or since this 2003 amendment, we have for the first time a breathalyzer reading which becomes an element of the crime.
She just said no. It's not a breathalyzer reading. It's the blood alcohol level.
The blood alcohol level, but the blood alcohol level is indicative or is determined through the use of the breathalyzer.
A test.
That's
a
right.
Test, which,
a test.
Which might be a breathalyzer.
That's right. And the breathalyzer, the element is that there's now 3 elements, and there's a second prong to the old statute, essentially, and that is that you not only have to be operating your motor vehicle, you have to be on a public way, but now the third element of this new way to prove driving under the influence is that your blood alcohol level at the time of operation would be 8/100ths or
But it was
greater.
always a way of proving that the third element was that you were under the influence
No.
at the time of driving.
Well, yes,
Yes, under the
under
influence, because you must be operating on a public way under the influence of intoxicating liquor. So of course it was because it was on a public way. You aren't on a public way when you're in the police station having your breathalyzer
No,
taken.
I'm not suggesting, and I'm not.
So it was always that way, and
It-
that was always an element that you had to prove you were operating under the influence at the time, and one manner of always proving it was a breathalyzer.
Well, that breathalyzer test was used as an element, not as an indication. It was one factor the jury could consider. Now, the jury must consider your guilt when introduction of your blood alcohol level is .08 or greater.
There's no other evidence on the point.
Standing alone.
There's no other evidence on the point.
That's right. You don't have to prove field sobrieties.
Nothing.
You don't have to prove the fact that the defendant was unsteady
Okay,
on
but
the
what's
feet.
wrong with that?
Nothing. Well, what's wrong is it rises to a higher level. Now, we can't assume that the legislature blindly enacted this law with the idea that an expert wouldn't have to be used. How else can one extrapolate? How does a juror, how does a layman determine a test taken at any time after the driver is first observed operating, let alone an hour or 2 hours, that reading can be extrapolated back to a .08
But
or greater?
it's just a question whether the legislature could determine whether the legislative facts are proper, and the legislature could arguably, they knew the tests aren't given on the spot, just like everybody knew, and they knew that there was a delay, and so the statute means, again, assuming that the tests are within a reasonable time, that the number at the time of the test is to be relied on.
But what is reasonable? What is reasonable to one
You
person
bring us one
versus
with 10
another?
hours, and obviously that's not reasonable.
But
But
on what
is
basis?
2 hours reasonable? Is an hour and a half reasonable? It's a floating line of demarcation. It's a floating time
Well,
period.
but wouldn't 2 hours be, everybody knows it's in a layperson's experience, except one who's never had a drink, that 2 hours later, you aren't going to feel the same way that you feel.
What if you have a jury
half
of teetotalers? Do we do a voir dire of the jurors to see what their experience is in drinking? I mean, I suggest to you, that you can read the newspapers and you can argue that somebody read something in the newspaper about a breath alcohol reading, but that's taking evidence outside of what is
The
presented.
legislature couldn't have meant bringing in experts. There's not enough experts in the state. And
There
there's
are, Your
hundreds
Honor,
of-
and I would suggest that there
There's
are.
hundreds of DUI cases being tried every
Absolutely.
day.
But every police department could have a member or more certified in extrapolation.
That's just what we need. I'm sure the legislature was intending to increase the cost for every municipality in the state, increase the cost of the police to come into court, increase the lengths of the trial, in a statute that they say is designed to aid the public safety in a
Aid the
difficult
public safety
situation.
and get federal highway funds.
Right.
So I don't know what was more we have to all assume that we don't want drunk drivers on the road, and all of the statutes said that we're to aid public safety, but we had federal highway funds. 23 states in this country have adopted a time frame where it would remove any speculation.
We may say a reasonable time and then take judicial notice, and the lowest that I've seen, and correct me if I'm wrong, of the 23 is 2 hours, and the most is 4 hours, and your client falls comfortably within that.
And that may be, but that's certainly not what the statute said. The statute said at the time of operation.
Justice Cowan has simply said if somebody came in here 24 hours later, okay, so, no.
I understand.
So sometimes what a court does, unless, and that's why I asked Ms. Pietzels, did they reject it, court does is say within a reasonable time period, then you come in and say what's a reasonable time period, and I take judicial notice of the 23 statutes that you've pointed out to me.
You need, Mike, with all due respect, to have uniformity. Bench trials, one judge could think that 2 hours is reasonable, another judge could say 3 hours, somebody else could say less.
How many of our statutes say reasonable? And we leave that to be interpreted every day in every court.
Well, When we're
case
dealing with a statute that says at the time of operation as opposed to at a reasonable time after operation.
Yes, but the legislature always, we're dealing with something that has a long and very well-known history in the state. And it always said on a public way, under the influence. And the test was always given at the station or in the barracks. And that was always considered sufficient and the legislature knew that. So why is there this great change? That's what I don't understand.
Because, Your Honor, at that time, just under Molly, as this Court ruled, it goes to the weight. But once the breathalyzer really becomes the element of the crime, the burden is on the Commonwealth to meet that burden, to show what it was at the
All the legislature
time.
intended, it would seem to me, by making that change, was they wanted to make it easier to convict drunken drivers.
It certainly,
that screams
there
out
is
to
no
you.
question that once those elements are determined in accordance with the statute, operation, public way, and .08 at the time of operation, there is very little, if any, wiggle room for the defendant. And it does make it easier. But at the same time, it raises the bar for the Commonwealth to prove that beyond a reasonable
But then
doubt.
you're saying that the legislature was intending to make it more difficult because they, by writing the statute, which facially looks like they are trying to make it easier to convict OUI defendants, they're trying to make it harder because they're saying the Commonwealth has to bring in an expert in every case. And that doesn't really make sense.
Well, let me just say this. Of course, they have the impaired operation prong that they could rely on. And at the same time, the Executive Office of Safety of the Commonwealth promulgated regulations since the statute was enacted through the Office of Alcohol Testing, where now they're required to provide retrograde extrapolation experts to the Attorney General and to the district attorneys. Also, they're required to provide retrograde extrapolation estimates. So they envision the need, I would respectfully suggest. You can't shift the burden of proving an essential element of the crime to the defendant. And that's exactly what the Commonwealth is asking to be done in violation of Commonwealth versus Medina, as this Court has ruled on in the past. And we suggest, Your Honor, that even though it might be somewhat more cumbersome to train police officers to become analysts in this regard, they've done that in firearms, they've done that in accident reconstruction. We're evolving, and this new prong of the statute makes it more difficult for a defendant. It doesn't provide any wiggle room. The video of him at the station is of no...
Your time is up.
Thank you very much for your attention.
Mr. Oskin?
Thank you. Good morning. May it please the Court, my name is Barry Oscar, and I represent the defendant, Jeremy Thomas. And I'd like to point out that, Justice Cordy, your question, a reading of .14 an hour or so after the time of arrest, what does that mean? It was precisely what I asked Judge Hadley when I filed my motion to exclude in the Greenfield District Court, which is that nobody in that courtroom knew, absent speculation, what my client's blood alcohol level was at the time of operation. And that's what the 2003 amendments has now criminalized. Now, I've heard, I believe Justice Graney and Justice Cowan, you've both mentioned, well, doesn't it just sort of make sense that a person's blood alcohol level starts to diminish, decrease, with time? That's sort of our common sense notion of what happens. The science tells us otherwise, that in fact, after a person has consumed his or her last drink, and I should point out that this was information that was presented to the district court judge, that that individual's blood alcohol concentration will continue to rise for a period of time.
Who presented that evidence? The defendant?
That's correct.
Okay.
That's correct. Would rise for a period of time, hit a peak, and then begin to fall off at a constant rate. The primary case in this field of retrograde extrapolation was a 1989 decision from the Supreme Court of New Hampshire, State versus Taylor. That was the case that the Commonwealth, during arguments at the district court level, primarily relied upon.
Well, where did your scientific evidence come from?
Did you have a doctor testify?
There was no testimony. It was based on reading and research that I had done that I incorporated into my memorandum of law.
So it wasn't an evidentiary hearing?
It was a
tested.
that's right, it was a non-evidentiary hearing. And
So in the record, we will see some medical journal articles and stuff about this?
you will see references to the scientific articles. That's correct.
But it's not presented as evidence. It was presented as argument.
That's right. This case
But
actually
he sort of
comes...
knows that anyway. I mean, it takes a while for the alcohol level to go up because your body's got to metabolize it a little bit, and you know, you might have eaten or not eaten, depending on, you know, that's a factor too, as I understand it. And that generally, I think, takes 20 minutes to half an hour.
In fact, in State
But then it
versus...
starts going down.
That's right. The question, in State versus Taylor, they pointed out that the time it takes an individual to reach that peak could be anywhere from 20 minutes up to about 2 hours. And that, when the question is, well, to give someone a breathalyzer test, say an hour after arrest, is that a reasonable period of time? From the standpoint of a police officer, we concede it is. But from the standpoint of asking a jury to take that breath test result without more and have them reach back in time requires too much speculation.
That's what they did under the old statute, didn't they?
No, because they weren't required to find, they could draw an inference, correct?
Two things were different back prior to 2003. Number one, there was no per se crime. We were simply asking the question, was this individual under the influence of alcohol? And typically, apart from the breath test...
While he was operating on a public way.
While he was
so
operating.
Back an hour or two ago.
That's right.
And some of the breathalyzer tests maybe weren't even given an hour or two. They might have been given later, and still they would come into court as admissible evidence on the question of operation on the public way.
And was that person under the influence of alcohol, which was a permissive but rebuttable presumption? What you would find would be that defendants could come into court with a breath test reading above a .08, but perhaps they're driving, but for, say, speeding.
Well, and they could also come in and say, geez, I drink a case of beer every day. You know, .08 alcohol level is nothing to me. The person's a lumberjack, and the juries can believe that. But now, if you have .08 alcohol in your blood, you could be driving, it doesn't matter how you're driving, you could be driving straight as an arrow. It's a crime.
That's correct. That's why we're saying that because the blood alcohol level at the time of operation, and that is written into the statute explicitly, because that has become so significant, that one breath test number, standing alone.
But your argument doesn't go to Justice Spina's question, because Justice Spina's question would still be as valid if you brought in the extrapolation expert. Yeah. You would still have Justice Spina's question. So that doesn't really address that.
Yeah, it appears from reading the statute and picking up on a point that Justice Cowan had made, everybody knows that you don't take the breathalyzer test, including the legislature, at the time that you're arrested. They bring you back to a police station. So the legislature seems to have written this statute that says that if you get a blood alcohol test, they don't say when, sometime after you've been arrested, taken back to the police station. If you get a blood alcohol test that reads a .08, that can be introduced in evidence to satisfy the Commonwealth's element of proof. And it's essentially incumbent upon you to try to chip away at that, to try to discredit it through cross-examination.
And our argument has been that under the new per se prong of the statute, that the third element of the offense, beyond operation, beyond public way, but that the individual's blood alcohol level at the time of driving, at the time of operation, needs to be a .08 or higher, that it is fundamentally unfair to the defendant to have to rebut that bare breath test number.
Why, so the legislature, in your opinion, has made sort of a new crime here?
Yeah.
And if so, why can't they do it? Entirely apart from any. They simply say, look, hey, if you're stopped and you've got a .08 or higher, you're guilty. You can be found guilty. They could certainly do that. They define crimes. Why do we have to debate whether you need retrograde analysis or not?
The question is, how does the Commonwealth go about proving that new crime? And we're saying...
Well, then you're down to her point. You prove it by the breathalyzer.
Isn't your point that the crime is not you are caught operating on a public way and at some point are tested, and if that test is 08, it says if it's 08 at the time of operation.
That's
and
right.
So that, and you're saying if you're 08 an hour and a half or 2 hours later, that doesn't tell you what you were at the time of operating.
But the legislature knew at the time they adopted the statute that the tests were given in the station, not on the street. And so unless we can say that it's unconstitutional for them to have done that, it goes, it seems to me. It's okay.
And you're saying, it seems to me, that there's no nexus between what his blood alcohol level was at the time he's driving and at the time that the blood alcohol test is administered. There's a gap there that needs to be bridged.
We're saying two things. I see that the red light is on, but if I could just make two responses to that question, because I think it gets at the nub of the issue before this Court. Number one, we're saying that breathalyzer results, standing alone, enjoy a certain uncontested scientific...
Well, the legislature has said that, period.
The second point is that I believe that there has been recognition on the state level that the expert, I'll call it look-back testimony, is necessary, and that is because the CMRs were revised, I believe, in July of 06 under 501 CMR Section 211, subsection F, that among the obligations is to require a report of retrograde extrapolation. That was never needed before, and I think that addresses the need for precisely what we're asking for. My time is done. I thank the Court.
Thank you.
All right.